in the interest of time, let's go ahead and move forward with our closing keynote session. We have a very special guest. He needs to be at another engagement, so he's very eager to speak with you, but then he has to head out. We're going to have the Honorable Author Burnett. He's going to come and share with you. I don't know if you all have had the opportunity to look on the website or to read through the program guide, his bio, but he's had an extraordinary career. But he's eager to speak, so this is someone who needs no introduction. He has a lot to share with you, and I'm going to go ahead and let him speak and give him the floor.
Good evening, young ladies and gentlemen. I'm going to bring you history this evening. Many of you weren't even born and thought about it. The Brown versus Board of Education was before the courts. But for 6 months, I faced death. I was involved in Brown. I'm the James Burnett of Virginia in the case that was ahead of Brown versus Board of Education. In October '54, Thurgood Marshall represented me with reference to becoming the lead plaintiff in the Princeton Edward Farmville school cases, and I applied to the University of Virginia Law School, October '54, under death threats of being killed by the Ku Klux Klan. I was in Malala, of the Negro race at the time. My case was settled because of Brown and because of Governor Forrest. But what you don't know is that I went on to law school because my case was settled in Virginia paid sent me to law school in New York, where Thurgood asked me to be as good as any Jewish kid could find in New York, and I finished in the top 10% of my class. And I played the most historical role in this country because I was assigned to Bobby Kennedy. How many of you see the movie The Butler? I was the butler of the Kennedy administration. I was Bobby Kennedy's eyes and ears in Martin Luther King movement. I was go-between between J. Edgar Hoover and Bobby Kennedy and JFK, and making sure the Communist Party would not overtake the Martin Luther King movement called Civil War in this country, to make sure that the FBI would not engage in unlawful criminal activities, and to make sure that black leaders did not commit any crimes. For 3.5 years, I performed the role of a CIA agent where I could not even tell my wife what I did. My phone was tapped and I was on the tail by the FBI to make sure I would not reveal any state secrets. It's only been in my administration that I've even been able to tell the public this much. But I want to tell you by way of inspiration. I was encouraged to go to Tuskegee to become a farm agricultural expert in 1972, or 1952, rather. But I had a dream to become a lawyer and write in civil rights and achievement equality, and working with diversity back at that time when people were judged on the merit of their ability and the quality of their performance. And indeed, before Brown was decided, I was on the radio with Adam Clayton Powell every Saturday, protesting segregation in America, and said that a person should be judged by the quality of his inner being. And it wasn't popular even something but him and her, that part, because women were considered housewives, maids, cleaners. They weren't considered in the public arena. But I say a person should be judged by the quality of his performances, not the performances, and not by the color of the skin or actually the race. And so I went to school with the commitment to sacrifice my life for desegregation and integration of desegregation in America. I tell you that because I'm walking history. Indeed, I'm the first Negro, a colored person that desegregated the bar of the District of Columbia. October 2058, Bar Association of D.C. only voted to admit Negroes or coloreds. October 14. 6 days later, a woman named Margaret Fuller Butcher and a young black boy named Arthur Burnett were the first 2 Negroes. She died 12 years ago. I'm lucky to be alive today, 79 years of age, to tell you this story. If you go on the internet, you will read in the American Bar Association Journal the story of what I just told you. only this past month, the Federal Bar Association has published a national story of my role in the civil rights movement in this country.
Wow.
But more important than that, it is an emphasis on 2 points I want to make tonight. Number one, you hear popular concepts on the radio that there's a glut of lawyers in America. They're talking about lawyers in the Fortune 500 firms that serve corporate America. But the 47 million people in this country do not have lawyers at their elbows, advising them of their rights as senior citizens, advising them of their rights as to disabilities. We don't have enough legal aid societies and public defenders, but we don't have enough minorities going into the prosecutor's office so that we, in fact, have sensitivity to cultural differences. And one of the things you need to learn from my 40-some years on the bench, and from 25 years of teaching law school as a law professor, that we are homogenous. We are all the same just because we look the same. We come with different religious backgrounds and family contexts and social values. So we have to judge the person individually. One of the most difficult problems in practice of law, and I want to emphasize the word practice, is who is telling the truth in factual trials, in credibility. How frequently do people make up their minds as to what the facts are based on assumptions, based on preconditioning, and indeed, who the president appoints as judges to the bench depends on the cameras they've had from the day of birth and their eyes and their experience and how they interpret the facts in the records. That's why you don't get unanimous decisions in the Supreme Court and in our public courts. So it makes a difference. And as we become more diverse in this country, and as we have people from all sectors of the world's population, we have a greater challenge to honor those words about diversity and pretrial and cultural competence. Now, from my law professor role, I want to say to you young people who are thinking about going to law school, number one, you've got to learn the legal principles involved in the field of law that you're listening or that you study, that you are participating in. But law school is different than college. It's not just a memorization procedure. It is a procedure where you must learn how to have the ability to analyze, to be an analysis, to apply the law so the fact is like a doctor applies a diagnosis to a medical illness. And then you got to mess and merge and kind of digest. How does that law and how do those principles fit to the factual analysis I need to make? And when I make the factual analysis, how solid are those facts over space? So one of the things you need to learn in going to law school is using that computer you got in your head called the brain to analyze what the facts are. And then how sometimes conflicting principles of law apply to it. And most of all, read and digest. Just don't act on impulse. When you're taking law school exams or taking bar exams, be as reflective and as thoughtful as you can. Be as creative and as innovative as you can be. I had the experience of being the very first African-American United States magistrate judge in America. I was appointed to the bench here in the U.S. District Court in June of 1969. And lo and behold, again, I ended up in the hottest seat in government. I became the assistant judge to John Sirica and Hammond Watergate, the death and resignation of Richard Nixon. And I handled John Sirica's entire criminal calendar and civil calendar, and was his assistant judge in handling pretrial motions and procedures in the Watergate case. I was, you may say, his shotgun rider. one thing that's very unique about this country. I'll conclude with this comment. The news media, monopolized by the money, capitalism, and many times by a Caucasian perspective of life, sweeps under the rugs black history, black achievement, and accomplishments in this country. But for the first 12 years of my career, I was in the tailwind of the civil rights movement and the major events in this country. I was the lead lawyer in the Justice Department. I was Bobby Kennedy's spokesman on the assassination of his brother. I was the spokesperson for the Justice Department in dealing with the FBI, Bradford Sanders, and the U.S. Attorney, and whether we could take Oswald out of custody, dealing with Ruby. But nobody talks about having a black lawyer being the leader of that team. And now I'm going to drop a bombshell on you. This little boy, 19 years of age, faced death. A year later, a generation later, father the son who invented Viagra. I'm the father of the inventor. Viagra may never existed if I had been killed in 1954-55. So black accomplishment, black achievement for a little rural country boy who was born in my mother's bedroom, who didn't have electricity in my house until I was 4 years of age, who learned how to read by lantern, ended up in his career being special attorney to Jimmy Carter, and legislative counsel in creating the U.S. Department of Education. In reforming the civil service system. You see, I'm the author of the Civil Service Reform Act of 1978 that created the Senior Executive Service, that created the Office of Personnel Management, the Merit System Protection Board, the Federal Labor Relations Authority. Indeed, at Carter got elected the second term, I had promises forbidden from going to the U.S. Court of Appeals, but politics plays great games at times. But the three messages that I want to send to you. Number one, you can come from poor backgrounds. You can end up in the White House. I thought I got the White House ahead of Barack Obama when I was talking to Jimmy Carter 3 or 4 times a week. It was his chief legislative counsel in dealing with the U.S. Congress, 1977 to 1980. I thought I had achieved a miracle. Miracle never done me in this one course. And I want to emphasize that there is a critical need for lawyers who are committed to the public interest, lawyers who are committed to ordinary people, people who may be able to pay a reasonable fee for your services, but not make you necessarily a millionaire, as long as you can live a decent life. I frequently tell my law students that if you open up an office dealing with Social Security matters, and you charge $75 an hour, $100 an hour, you have people standing around the block waiting to get in the seat and make sure that Social Security entitlements were properly handled, or that they were eating entitlements. Or if you were running this, and you could make up in volume where you could earn $250,000 or $300,000 a year. But that's a need that goes unadjusted in this country, unaddressed. Public interest, prosecutor's office, public defender's office, legal aid office, neighborhood legal services office needs more people with diverse backgrounds. People like those of you I see in front of you right now, in front of me. And there's a crying need for poor people living under poverty. 47 to 50 million people that Children Defense Fund and American Helmet is concerned about through my work for 6 years. To make this country all that it can be. Unfortunately, prejudice, bias, even unbiased prejudice, has in fact deprived this country of the human capital and contribution that individuals, regardless of the color of their skin, or racial identity, or their national origin, from all backgrounds, could have made far more significant contributions to the quality of our society than we see it as today. I wanted to share those views with you in the short time I have for that another engagement. But I wanted to inspire you, and I wanted to tell you what the Challenge Law School is all about. I taught at Catholic Law School for 12 years and Howard for 13 years before they got made me kind of the intern management where I'm the counselor, but all the students in law school. I'm like the judge in residence at Howard Law School. And so I have 3 or 4 speaking engagements a day. I came to shadows